So we're trying to discuss today in this session about the draft data protection bill that Ministry of IT has put up after Sri Krishna Committee report. This has been going on for some time, and there was a Supreme Court judgment, and a lot of people, organizations were pursuing this. Especially iSplit was pursuing this, and in light of our DEPA initiative. Siddharth will speak more as we progress on DEPA. And Supratim, Supratim and Siddharth both have covered earlier one more interesting topic related to this on GDPR, which is interesting for people who want to do business in Europe. So I think gradually India is catching up, and we need to discuss what this draft regulation is and how does this affect our industry and how can we make use of it. So, Supratim, I have been going through some of the documents available and material available. So we will need your we will ask you to enlighten us on a few aspects. So, can I start with the first question, which I have in mind is how does the draft bill, cover the privacy aspect, and what restrictions does it propose in the present form?
Okay. So first, the distinct. Unfortunately, what I observe in various drafts, there's a huge mix-up in the thought process behind privacy and protection. Okay, I think it's very important for protection, so to say. So if there is a window really, and if someone can see through into the room from the window, it may be called a breach of your privacy. But if someone can break into the room from the window, that would be a breach of protection. Okay. So there are two elements really, whilst quite intertwined at times. However, conceptually they are quite different. Okay. The present draft actually tries to address both of these. Okay. And there are several avenues as we go ahead during the course of this session. We'll discuss all of these. But what we observe is that through this particular bill, there is a relationship of trust which is which has been tried to be established between the data subject and the data controller. The nomenclatures also have changed. You would have observed. It is now data fiduciary and data principal. So, whilst the draft bill stops short of really mentioning that who is the owner of the data, whether the data principal is really the owner of the data. However, from all other perspectives, it kind of builds in that concept. It puts a lot of onus on the data fiduciary to take care of the data protection aspects of it and the onward processing, etc. There are several avenues. I think as we go ahead in the discussion, let us pick up one pocket each and discuss. I'm sure that we would be discussing things like cross-border transfer of data or data localization, which are the hottest parts of the bill, I would say, and much debated about. But yes, there are concepts like privacy by design, more transparency requirement, security safeguards, breach notification requirements, grievance redressal related mechanism, requirement for having data protection officer, record keeping related requirements, impact assessment requirements, etc. So yes, so these are the broadly stating, these are the parameters which have been drawn up.
Okay. So on the data fiduciary aspect, so what is if we can understand what restrictions does it impose on if I am collecting some data from any, or any other third party is collecting data. So, are there any specified restrictions on kind of data?
Yes, so let's start from the very core aspect of grounds of processing. Okay, so it very clearly sets out certain parameters of what grounds of in the processing can be carried out. Consent, of course, is one of the grounds that is there. Apart from that, also there are certain other avenues which have been created only upon pursuant to satisfying those requirements you would be able to even onboard the data and further process
Okay. And so, apart from data fiduciary aspect that you brought in, is the state and government, is that are they exempted from it, or?
it. Yes, so basically there are certain avenues provided, but this law would be equally applicable to private parties and the government. That was one of the endeavors of the lawmakers also. If you remember the earlier provisions that we had in the Information Technology Act, which is basically section 43A and 72A. 43A would be actually scrapped after this bill comes into effect. That did not have real applicability on the government, and that was a huge question mark, which was there was an intent to address that. But yes, yeah, there has been a move, and now the government is also under the purview of the requirements provided in the bill.
Okay, and if we compare it to the GDPR, a few of the aspects of GDPR, is that equally applicable as far as consent to withdrawal is concerned, or something like right to be forgotten?
Yes, so right to be, yeah, right. I think very good question actually. Right to be forgotten has been perceived a little differently under the law. It's basically a right against further disclosure, as against global understanding of right to be forgotten. Our lawmakers have tried to look at it slightly differently. I would say it's a little business-friendly way of looking at it. That they have just said that any further dissemination should be stopped.
Okay. So any further dissemination means, okay, so so the owner of the data can specify, or will have to provide consent, and you can't go beyond. So the level of consent also has to be provided. Are you really hinting at that, or?
No, so I'll tell you. So basically, the way right to be forgotten is perceived otherwise globally. It is erasure of the data, removal of the data completely from the systems of the person who's handling it. Here, basically, the requirement is if the data principal comes and tells you that, okay, I would like to exercise my, right to be forgotten. It's kind of saying that you then further do not disseminate that information, contain it at your end.
Okay. All right. And I was also seeing, there are a few more aspects of it is, for example, data localization, that probably you will not be allowed to take the data outside the country, or there, as you were mentioning, the important and interesting aspects of cross-border transfer of data. How will that be handled? How is
Right.
that
So I
being
think
addressed?
let's stay on the aspect of data localization for some time, and
Mhm.
let's spend some time on quality time on that. The reason is it's a very important topic aspect, and you would be observing that not only this particular draft bill, but several other policy drafts that are now getting rolled out or being spoken about contains the provision of data localization. We have observed the e-commerce policy. the cloud computing policy which is being spoken about. Sorry. So all of these have an element of data localization. Recently, the Reserve Bank of India had told that all the payment systems related information should be fully located, within the country. Of course, we hear that after that there has been, some discussions with the Ministry of Finance, and there's a possibility that some relaxations could be thought of. But the point here is, let's go back to the requirement of data localization. What's the requirement really? There are several theories to it. Some people say that there could be a trade theory, which simplistically utilizing the data of a country for the usage of that particular country only. But I think security aspect, the security theory is a larger theory here, which is in simple terms that the information should be housed in the country, because if the government requires it, they can have access to it. Now it's a double-edged sword really, because there is a there's a possibility that there could be surveillance, and there could be easy access of the information to the government. What has been really told in this particular draft bill is simply four things. One, you could have certain pockets of personal data which can be freely transferred outside. There could be other pockets of personal data which you can transfer. However, a serving copy of that particular data has to be within the country. The third category is sensitive personal data, and the ambit of sensitive personal data has been widened quite a bit as compared to what we used to see under the 43A of IT Act and the sensitive personal data rules. So this category of data, if it is getting sent outside the country, again, a serving copy mandatorily has to be kept within the country. And then there's a fourth category, which is the critical data, which if that cannot be sent at all outside the country. So what has happened presently is there's a huge debate around this whole localization concept, because the color or the picture that is being drawn is the government would be largely thinking of having at least a mirror copy, a serving copy within the country. Now, this would escalate the cost of doing business quite a bit. Okay, right from the startups to the larger players, there has to be arrangements made within the country for service, saving of the data. So very simplistically speaking, we will have to see how the further rules and regulations that are sought to be formulated, they bring in the elements of this personal data and sensitive personal data. But nonetheless, business would not be the same. You will have to think differently when you are thinking about storing or saving of data.
Okay, so we can understand there's not a simple point to address immediately, but there would be debate on this, and I would definitely ask Siddharth to come in when we discuss data with respect to these issues. So one more aspect, Supratim, in the draft law is about bringing in a regulatory body, which they are naming it as Data Protection Authority, DPA. How much scope does the DPA has in the draft bill as far as regulating it is concerned?
Yeah, sorry, Sudhir, I'll apologize. So I think there was a second part of your question which remained unanswered. I'll come to the Data Protection Authority related question, but before that, I would like to just touch upon the other question on cross-border data.
Cross-border, yeah.
Yeah, sorry. So I'll just finish that. So basically, in simple terms, we are now envisaging something like standard contractual clauses and intra-group schemes. You can either have the transfer through that mechanism, The central government can also, after consultation, prescribe certain jurisdictions, certain areas where you can sort of transfer. You have another avenue, which is consent. But mind you, if you are triggering the cross-border transfer through consent, you necessarily have to have the first two elements either of the first two elements that I spoke about. Either you have standard contractual clauses or have intra-group schemes, or the central government has approved it. Apart from that, there's a fourth avenue, which is basically for necessity. So these are basically the pockets which are available for businesses to transfer data. Now, coming to your question on Data Protection Authority, you would have observed that this seems to be like an all-encompassing, all-powerful authority, which has got several powers. Okay, rule making, several advisory, and therefore it becomes very important to see how it really shapes up. If you, truly speaking, if you look at your old, the provisions that we had, the ones that we just touched upon, say Section 43A of the IT Act or 72A of the IT Act, these were largely there to help plug the requirements of data privacy and protection. The problem was with enforcement and implementation, right? So we will have to really watch out and see that this all-powerful authority that we are talking about, is it really able to, enforce the law the way it is drafted?
Yeah, so it seems very difficult that from one single point you can enforce the law. But let us see the aspects, where they would be authorized to do inquiries, take action, against data processors. I don't know. Time will tell how this will happen, because on ground it has to be the local enforcement which will work. So I think that's an important aspect to understand. But let's see what happens further. So, are there any other interesting aspects which you can touch upon, which you think are important for our ecosystem to understand?
There are several interesting pieces which are spread all across the bill, and I would love to speak on each of them, but because of paucity of time, maybe I'll touch upon few. So one is the requirement of having your notice in multiple languages, okay, which is not a very hard obligation the way it has been put, but in a country like India, we will have to really see that, say, an e-commerce platform. Imagine the amount of additional cost that would have to be incurred in order to have multi-language notices. Also, are we really being able to address the point of informed consent through this? Because you also have a segment of people who are maybe illiterate, okay? So we will have to really understand, during the Justice Sri Krishna Committee consultation meets, there were several other suggestions also which were put forth. One was that, should we have like maybe short videos or graphical, some representation, which makes it very easy for someone to understand the critical aspects of privacy that we are speaking about. So I think this is one. The other important piece, let me just check my notes once. I was going through these. Okay, so I think the other important piece would be the applicability piece. So you are aware that this particular law is applicable to any kind of processing which is happening in India and also to foreign bodies. There, when in section 2.2, where we are talking about applicability to foreign bodies, the first part says that in connection with any business carried on in India. Now, this could be like a very nebulous concept. You can have a global platform website which by the by is accessible from the country. Now, if you do not have a clarification there, it would mean that even that particular website has to follow the entire requirement of this law. So these are small pieces, and we have many such. But I think
what do you
we
think?
have
You know,
subsequent
is
sessions going through these, but
yeah.
these
So,
are what I must share with you.
are we going in the direction of GDPR? Do you think like that, or is it a very lighter version now?
So no, so I think that's the idea, really. If you look at it, and I'm now talking about from a very business perspective. We all are aiming towards the gold standards that are there, and the whole, I think all economies, say several geographies, are trying to adopt the principles that have been already mentioned in GDPR. The idea is that if we can have such gold standards imbibed in our law, and we can have a more robust economic exchange of information, I think that is the real goal or aim of the government. Of course, India is quite different as far as applicability or rolling out of this law is concerned, and we'll have to be mindful that not everything is possible. Only a simple copy paste job will not work. However, the idea is to slowly but surely reach that particular zone where we can have our laws which are quite akin to the other mature jurisdictions that are there. If you observe today, all countries, I think, doing a catching up game right now. Okay, technology has far surpassed the laws that are there. Okay, we were taking help of our Indian Penal Code, Telegraph Act. All of these we were taking help of to address the situation of today. So therefore, there is a requirement to really upgrade, scale up. And the way I think we have tried to do this is basically have an umbrella legislation through this particular bill that you see. Under this, we will still have the sectoral regulators play a very key role in preparing their laws. However, those laws have to be in sync with the mother legislation, which is this bill.
Okay, great. I think that's a very nice explanation, Supratim, summing up. Let me bring in, if Siddharth, you are there, can you come online?
Yeah, I'm available. I can hear you guys.
Okay, so I think we would like to understand, Siddharth, from you the how does DEPA gets connected, or how is DEPA addressed in this draft law. I think first of all, for benefit of listeners, can you in brief just tell about DEPA, what it is, and then if you can explain us how is DEPA addressed in the draft bill.
Sure. So fundamentally, the way if we look at the privacy bill, at least in my opinion, I feel it's a very unique India first approach. And the reason being, not only does it, as Supratim started off saying, address privacy and protection, but a very key part of it is understanding the fact that we are a developing economy, a developing nation. And so it also addresses empowering Indians with access to their data, right? And therefore looks at, besides for protecting their privacy and other such aspects, how do we give them control? How do we empower them so that they can, using their data, access better financial services, better healthcare services, education, so on and so forth. And so actually at iSpirit over the past 3-4 years, we've been constantly working on consent layer of India Stack, or the consent framework. And it's great to see that the bedrock fundamentally of the draft privacy bill is actually based on consent. While they do have, and they go on to set strong standards for consent around must be free, fair, informed, etc. While they do have certain grounds for non-consensual processing for the public functions of the state and other such reasonable purposes, but to a large extent, data flows are based on the data principles consent. Now, this is in some ways similar to GDPR, but one of the biggest problems that you see taking place in the EU today is it's very difficult for them to actually operationalize consent and other such rights that they've outlined. So for the first time, India actually has a unique infrastructure to operationalize consent. So DEPA is nothing but a set of two tools. One is known as the Digital Locker System, which allows federated exchange of data, and one is known as electronic data consent, which is nothing but an electronic representation of your user's consent. What does that mean? That basically means, let's say you want to share your data from some provider to another consumer. You must be able to express what data you want to share, with whom, for what time period, etc., in some codified manner. And that's known as the consent artifact. So the consent artifact became a national standard way back in 2016, which was then adopted by the four financial sector regulators, RBI, PFRDA, IRDA, and SEBI. And they adopted it for their entire ecosystem. So what they essentially said is, based on the consent artifact, every individual has access to their financial data and has the mechanism to share that data to gain access to a loan or any other such service providers. The way they've done it is they've actually come up with a very unique institutional innovation called account aggregator, or what we term it as a class of entities known as data access fiduciary. Now, what the account aggregator does is it actually, unlike other parts of the world, decouples the institution that's collecting consent from the institution that's either consuming your data or providing your data. And this is very important. In the EU, for example, as part of the PSD2 directive, the account information service provider, which consumes your data, is also responsible for collecting your consent. But we've decoupled that out here in India. The beauty of that is because now, going forward, through the account aggregator, and about 3 account aggregators have been approved. The technical standard drafts are also out for the entire ecosystem, and it covers all your financial information. Through the account aggregator, you actually have an entity that's working towards creating an informed consent experience. So whatever concerns that Supratim had raised around notice, around video, around how do you create informed consent, because there were no incentives for the provider or the consumer of the data to do that, all of that would actually happen through the account aggregator environment. So going forward, if you have to imagine, just like on UPI, you receive a collect request for your money. Going forward, you can actually, through the account aggregator, receive a collect request for your data, right? And it would have a bunch of information, structured, multilingual, all of that, because the account aggregator has to innovate. It has to get more users. That means it's going to innovate in localized Indian context, etc. So whatever objectives the bill spoke about in terms of consent, you actually have an entity whose sole business model is actually achieving those. So that's how the account aggregators and DEPA is playing out in the finance sector. But we expect a similar model in telecom. And so if you go back to TRAI's recommendation to the government, which came out earlier this year, they've actually proposed a similar class of data access fiduciaries or an account aggregator equivalent model for telecom data. And if you look at the recently published National Health Stack book by Niti Aayog, it talks about a similar concept around health data. But that's basically the track through which DEPA has been progressing. And it's great to see the thought process around consent strongly encoded in the privacy bill. So that's the way we've been looking at it.
Okay, so I think on the account aggregator side, probably that would work as a proof of concept. And as you said, Troy has already, followed that line. So don't you think, or another way, let me ask this question: has the account aggregator kind of concept has it been addressed in the bill, or do you feel that it needs, if not addressed, it has to be there?
Yeah, so there are two, three levels to this. One is the bill makes the bedrock of most processing of data based on consent. And the entire account aggregator model is actually nothing but a consent collector or your consent manager, right? Second, the bill in the right. So every data principle has, every data principle, they've outlined four rights. Right to confirmation and access, a right to be forgotten, right to correction. But the most important one is something known as the right to data portability, right? Which is basically, it states that as a data principle from data fiduciaries, you have the right to request and port machine readable, structured, non-repudiable transaction history or any other user generated data to another service provider, right? Now, given that that's a right, the account aggregator is nothing but a framework to operationalize that right. And if we go back to the report, the larger report of which the bill was a part of, they actually spoke about a concept called consent dashboards, right? So they had two technical innovations. One was a consent dashboard and one was a data trust score. So the account aggregator or our whole data framework is nothing but a consent dashboard, right? So it basically allows you to receive consent requests, approve them, revoke them. It's all auditable, so you can actually log consent flows, you can log data flows, and stuff like that.
So we are expecting some kind of consent dashboard being, developed in other areas, other sectors. RBI is regulator in the financial sector. That is how the whole thing was developing for a long time, and it has progressed well. But in other sectors, do you think only one authority or one, or will it come under the Data Protection Authority, DPA, some kind of a consent dashboard architecture will develop? Or do you think that this
Yeah.
sectoral? I think sectoral may not be possible because how will you cover various large sectors? For example, just for marketing, purpose, if who will govern, where does it fall under, which jurisdiction? So I don't know, but it's my feeling. Probably Data Protection Authority will have to work on this, and some kind of constant dashboard mechanism has to develop there.
It would be a combination of both. So if you look at it, and if you read the privacy bill, what it essentially talks about is it empowers sectoral regulators to write rules in their corresponding domain, right? And so therefore, for data sets that are present in regulated sectors, finance, your healthcare, your education, your skills, telecom, those are things that the regulators themselves would prescribe the framework for a consent dashboard or a common consent dashboard, etc. That being said, there is and these are largely the most socioeconomically the most important data sets for an individual's life. But aside from that, a lot of data falls into what category we refer to as private data sets, right? So say your social media data and so on and so forth, for which the Data Protection Authority would definitely prescribe a standard. However, what it can say, and that's what's reflected in the report, is the dashboard can be maintained by each data fiduciary, or it could be a common dashboard that everyone agrees upon, right? And so if you look at the account aggregator, it's really a common consent manager, a common consent dashboard for the entire financial sector. But say for social media companies, the Data Protection Authority might just ask them to maintain their own dashboard, right? And that's for any software product companies, for example. not operating in these regulated sectors would offer their own consent dashboard, where the user can come see what data they have processed, correct the data, post the data, manage their consent, etc.
Yeah, so from software development, software product companies' perspective, anybody who is in software, whether it is a product or not, probably this particular bill will become very, very important. Unlike the IT Act, where the IT Act was not directly affecting them, but now any development of a product has to take in account all these aspects because they will be directly linked with how you present, how you collect data from users, and how you process data. So there's a direct implication of the law. Probably we need to see how this draft bill further becomes a law and how this unfolds in detail. What do you think, Supratim? And
Yeah.
how does it?
Yeah, of course. The ambit increases quite a bit, as I was mentioning. So wherever there is any interface as far as personal data is concerned, or sensitive personal data is concerned, the level of compliance requirements have gone up several times. On this, since you touched upon the old law, what I would also think about is basically there was another avenue in the Information Technology Act, it still is. It's 72A, which is talking about personal data. Okay, that still remains in the IT Act. So if you look at the present draft bill, it does not talk about deletion of 72A. So it will be a very interesting aspect again to watch out for, that whilst more or less what 72A tries to plug is already there in the draft bill, you would still have a parallel mechanism maybe set out in the IT Act.
All right. So I think Siddharth, we will have to keep following this topic. I think it's going to become very interesting. Just like GST, this is another law which will become very, very important for the software product industry or businesses who are in general, for every business, because somewhere or the other they would be collecting personal data and processing it, and everybody will need to comply with it. So, any comments from
and
you?
not only from a compliance perspective, I think what this law also unlocks, while compliance is one part, but it really unlocks a whole host of data and business models around data sharing, around consented data sharing, that you haven't yet seen in any other country, right? Because the user is now in control. He can share it with any service provider to gain access to services. And I think that's going to be an interesting space to see what companies get built out there.
Okay, so huge opportunity for a lot of startups, right? At least some of them to come up. Okay, so I think that's a very interesting part of it. Anybody else who has a question, who's joined the meeting and has a question? Any of the participants?
Yeah, hi, Sudhir Chintan here.
Yeah.
Just a couple of questions I have. One is I didn't attend the GDPR call, so I'm aware of GDPR, but not really aware of what was discussed in the call. But see, for a SaaS product company, if it's in a B2B space, just from my understanding, when we talk about data storage versus data processing, every product company is going to do data storage. That's clear. But what is definition of data processing? If it's an ERP company providing a SaaS ERP, would we say it's data processing?
Or you are an ERP company. So Supratim, can you comment on this? It's a little bit of...
Yeah.
differentiation in the the processing.
I just want to understand data storage versus data processing, and where all will this apply? If you're an email service provider, you're providing email, Google, Gmail, is it data storage or data processing?
Right. So I think, of course, we have to see how this shapes up finally. But Chintan, what I would, say here is that if you look at the definition of processing, okay, it is extremely wide. And just allow me to quickly read this for you. It says processing in relation to personal data means an operation or set of operations performed on personal data and may include operations such as collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, use, alignment or combination, indexing, disclosure by transmission, dissemination or otherwise making available, restriction, erasure or destruction. So extremely wide, and I get your point completely what you are driving home, but it is extremely difficult to get out of it. If someone has to really point a finger and say this is processing, it will be very difficult for you to wriggle out of it and say no, this is not processing.
Mm-hmm.
That's how the English is formed by the policy.
No, it's extremely broad brushed. So there could be people who would actually fall into this category without actually being a processor. There is a high possibility. There are businesses which would easily fall into this category without being a processor. Really.
Yeah. And any view on the timelines? Like it's a draft bill right now.
Yeah. So I'll tell you what. So basically, when this was put forth, when this was handed over by Justice Sri Krishna to our IT minister, what he said is this is a draft bill which has been presented to the government. It will undergo deliberation. So the MeitY has already declared on their website that till 10th of September, stakeholders can give comments on this particular draft bill. We all are working, with several of our clients ourselves. We are putting together our thoughts on the lacunas that we observed. That there are several, of them. Thereafter, it would go into the parliament, and the timeline after it gets promulgated in the parliament, the entire thing will come into effect in 18 months. So that's the total horizon that we're looking at.
Okay. Yeah, it will take time. I think there were a lot of apprehensions on whether they will put in this bill, but it will take time, the processing of it. Yeah. So I think that's very. Anybody else who has a question? I think there are a couple of people there in the back. Okay, so
hi, Karthik here.
Yeah, Karthik.
Yeah, so what happens to the existing customers? Like, do we go back to them again, get their consent to process their data? So what happens in those situations?
Interesting question. Yeah.
Interesting, and whilst the thought is that it will be a prospective legislation, doesn't really go into the retrospective aspects of it. However, as you would have understood that if you have to continue processing, you would probably fall foul of the requirements of the law if you are using the data without taking, whilst the law says that it's done for your present day requirements, you'll have to follow the law.
So I think the present draft bill will further evolve, and there are technological aspects of it, but there are much broader detail as we progress further. And probably we will need to cover it in few parts, the different legal aspects of it for businesses to understand. If there are no more questions, we can close the session now, and maybe in another second part.
Just another question.
Come back.
Are there any fines defined here? Have they already decided what range for the fine if someone is in violation of this law?
Oh yes. And like we have been thoroughly inspired by GDPR on the fines, also we have been highly inspired by GDPR. So we have this 4% and 2% bucket here also of the annual global turnover. So there are two buckets primarily, apart from the other penalty-related aspects which are mentioned. One is 4% and 15 crores, and the other one is 2% and 5 crores.
Okay.
Okay, I think that explains. Yeah. Yeah.
And do we need to appoint an DPO here to look after this?
Yes,
So
there is a segregation which has been made of significant data fiduciaries and the other data fiduciaries. So the significant data fiduciaries under certain conditions would have to have a data protection officer. But just to be very clear here, this particular law has immense amount of delegated rule making power, rule regulation making power. Okay, so we will have to really see when all of this comes together how it pans out, because today most of the provisions would look very fair. The reason is it just leaves open the scope. Okay, this would be further detailed out in the regulations or as may be decided by the authority. That the authority is just enough to give you something which is balanced and which is business friendly, maybe it will look fine. But if there they go wrong, like they did with the set of rules that they framed under 43A, if you remember, Section 43A gave the rule making power, and they had left only two avenues. It said that the rule would basically define what is sensitive personal data or information and set out what is reasonable security practices and procedures. In the rule, we saw a plethora of requirements were set out. Maybe some of it was also over legislation, extremely badly drafted. If you read the rule, you will see somewhere they're talking about sensitive personal information, somewhere they talk about only information, somewhere they talk about personal information. So to plug all of that gap later on, they had to come out with short point being that there is enough to come right now. What you see is just the tip of the iceberg, I would say. There is firstly crystallization of this particular draft which is required. Secondly, there would be a lot of rules and regulation under each of these pockets which will really set the tone as to what you have to do. So this is just a basic framework.
Yeah, this is just a draft bill, and once it becomes law, so I think there's another stage, as you're saying, they will come up with rules. There will be a DPA authority. How will that function? It's all, it has to be seen. So I think we are running short of time now. I would like to bring this session to close, and we will post this as a blog, and we will welcome any questions further, and probably we can keep on getting into discussion mode over there. We would like to cover this in further detail as we make further progress on this subject. Thank you so much. Thank you, everybody.